chorus of thanks to the University of Missouri and to Peggy in particular. I'm a pretty decadent person that divides my time between Charlottesville, Washington, and Paris, and to get to come to the heartland is a new and wonderful experience. And damn, it's cold here, I have to say. This paper actually arises out of a very inside baseball situation, which David and Duncan are both familiar with, but I think it has a broader set of implications, and I want to talk about the broader set of implications. The two treaties, the one we've signed, the one we may sign, and how we implement that are still issues to be worked out. But I'm interested in these as instances of a general problem. And let me begin by saying that on my big picture, I of course agree with my good friend David Golliff on everything. I admire and respect people who do textual and originalist work. I have some great colleagues at Virginia who do that, but that's not the game I play. I'm interested entirely in understanding institutions from a rationalist perspective, and historical origins are evidence, but for me, but only that. I'm really interested in the concern about localist opportunism as motivating the argument for federalization of international law. Seeing that concern expressed in Swift and Tyson, which Story at least thought was an international law decision. He thought the law of negotiable instruments was international law, not to be held captive by any one state, particularly a state like New York, which in that case seemed to be acting opportunistically to deviate from a general pattern, perhaps for special advantage. And the argument for federalizing international law is, of course, just that. Congress knew that you couldn't count on the states to uphold the international obligations of the United States. That's why we got the Constitution. There really wasn't much else going on. And I think what we know now is that there actually are a number of ways that we can honor our international obligations without involving Congress and, from my perspective, much more importantly, the federal courts at all. And to think about those contexts where it's at least possible. I rather simplistically divide the world into collective action problems and coordination problems. Arguably, the law of negotiable instruments potentially presents coordination problems. I think child support almost inarguably does, in the sense that you imagine the incentive is that we want to protect our kids and our deadbeat parents if we possibly can. And of course, the collective action problem is to get to where we only protect the kids. I think the electronic signature example is an instance of a coordination problem. It's kind of like what side of the road you drive on. It's hard for me to see what rents could be derived from having a non-conforming electronic signature rule. Or at most, it would be a one-shot kind of rent, where this one time we don't want this deal to be valid for a local advantage. But I don't see going forward why you would have a separate set of rules from the common norm. And what we see is that Story might have been right at the time he decided the case. It might have been that the commercial markets of his day were insufficiently developed, particularly because of the existing information and transportation technologies, to discourage New York from engaging in opportunistic behavior, from having a rule that protected certain local interests, perhaps. But by the end of the 19th century, the banks had gotten to the state legislatures and supplanted the specific federal common law rule of Swift and Tyson with a statute. And then in the middle of the 20th century, we got yet another set of statutes that again deal with this. And we did all of this without any federal government supervision. And we got a rule that now codifies exactly the common law, general common law rule that Story embraced, even though we removed federal supervision from the game. I think the bank story is a story of competition and race to the top. That's to say, I don't see the distributive politics in the law of commercial instruments. I see it as simply sort of gains from standardization. And driving that was a concentrated industry, the banking industry, that did not have any concentrated groups on the other side, and so not surprisingly, I think, at least it would be predicted that we get what we saw, which was a standardized set of statutes that's adopted universally. Another way to achieve the same result is by bribing the states, and that's essentially how the child custody regime works. The electronic signature instance is one where we don't need coercion, because once there is a lead as to what the norm will be, there's really no reason to deviate from it. Just as not driving on the right has sanctions that are independent of what the state troopers do to you. Not using a conforming electronic signature, or not having a law that recognizes a conforming electronic signature has its own sanctions in terms of the effect on local transactors. As David Golub said in his remarks, it's really all about the externalities. Some externality problems can be solved either with bribes or with the kind of iterative process that induces cooperation internationally. And furthermore, and probably David wouldn't agree with this last comment, we always have to remember that federal action, particularly if it's delegated to the courts, has its own externalities. That it would be great if justice is always what you got in the courts, but we have good reasons to think that there are systemic problems with litigation, particularly private litigation, and so that we shouldn't automatically fall back on having it a federal rule enforced in federal courts as our default of how we want international law to proceed. Implications for cases like Medellin are obvious, but I'll leave it to others to draw them. Thank you.
Yeah, I think we decided in a coordination game that Julian's paper goes best after Paul's.
Thanks, and yeah, thank you so much. And as I jump in here, calling it a paper is obviously an overstatement. It's more of a few thoughts. It is a sustained argument, but it's not, as you can see, a developed paper yet. And in my defense, and also, as you can tell, I only circulated it seconds ago, and and that was strategic so that you weren't able to evaluate it ahead of time. But also, in my defense, I raised the first-time new parent defense, which some people are sympathetic to, but others don't seem to find all that. And that's sort of been consuming me. And so let me just issue a couple of disclaimers. This sort of to sketch out some ideas I have, which are going to sound a little bit building on what Paul's paper does. It also builds and expands on some prior work I've done in the past, and especially in North Carolina, a law review piece I did a few years ago, and to try to sort of expand the thoughts I developed there, and will hopefully be reflected in a forthcoming book I'm doing with John Yu on foreign affairs law. All right. So let me just start by saying that, in my view, I make the claim here that state governments in the United States are the primary governmental actors in the development and integration of private international law into the United States. And what's interesting here, and here I try to link up a little bit with our discussion from the first panel, states play this role even though there appear to be, and I think there's some emerging defenses, but there appear to be very few serious if any, constitutional constraints on the ability of the federal government to sign, ratify, and maybe even implement private international law treaties and displace state law. So this, to me, raises at least two important questions. Like, why does the federal government refuse to displace state control over the integration of private international law in the U.S. legal system? And the second question I want to address is, does this system of decentralized state control, or at least state participation, in the integration of private international law treaties in the United States have any implications for the integration of other types of treaties into the U.S. legal system? And so here, let me sort of, my basic conclusion I'm going to argue here is that the federal government's reluctance to displace the states in a lot of these areas reflects, I think, the stickiness of traditional federal state allocations of lawmaking powers, even where unlimited plenary federal authority to intervene in state law appears to exist. The primacy of states in the integration of private international law, I also argue, and even in a world of plenary federal power, maybe, points the way to a model, at least in my view, of accommodation of other kinds of treaties that sort of impact traditional areas of state control that are similar to private international law. So, while many observers, I think, embrace a kind of reflexive nationalism that maybe Paul was suggesting on all matters touching to international law, this model, the model that private international law treaties in the states provides, I think, offers a healthy, maybe modest alternative to what I sometimes call, in my less pleasant moments, knee-jerk nationalism, right? Multinational, pervading some our thinking in this area. So let me just sort of develop my first claim and try to be brief here. I argue many, if not most, key areas of private international law remain questions of state law. So states control questions of private international law in three ways. First, there are a number of areas of private international law, such as conflicts of law or recognition of foreign judgments, where there just simply is, the United States is not actually party to a treaty, even though there are treaties out there which the federal government could enter into, and there's not even federal legislation in this area, or at least not important one. So that's one way the states control it because they have the federal government has done nothing. Second, the federal government has entered into treaties, and then they rely on the states to either jointly implement the provisions or rely on the states to alongside federal legislation. So in this model, states will essentially adopt legislation that kind of is like a reinforcement, the belt and suspenders. Like there's federal legislation implementing it, the states adopt regulations to implement pretty much the same provisions just to make sure, for some reason, to make that clear. And third, and most intriguingly, states will sometimes implement international treaty obligations that the United States has signed but not ratified, or maybe has not even signed. And in those cases, so you have a situation where states are essentially implementing, they're not technically implementing international treaty obligations, I suppose, but they are essentially adopting conforming regulations to implement private international law treaties, the equivalent treaties, even though the federal government has not gotten around to ratifying or implementing those treaties. So just as a quick sort of survey, there's a lot of treaties which the United States we are familiar with, where the United States is party to, which are private international law treaties that are implemented via self-executing treaties or legislation. I don't need to sort of point to this crowd, but those are the CISG is the most prominent example. The New York Convention on Recognition and Enforcement of Arbitral Awards is probably another big example, and there's a few others. But what I'm suggesting is that this list leaves out large questions arising from the questions of foreign court judgments, foreign private law instruments such as wills, adoptions, divorces. And so many of these areas, especially, remain non-federal. So I have the list of some, and I shamelessly stole this from the State Department Legal Advisor's website. Those things which are simply just not, either signed but not ratified, signed but not implemented. And let me just quickly point to what I think is kind of a neat example of how the states get involved. There's a lot of these private international law treaties, even the one involving, I guess, in our parlance, notaries and the legalization of documents, where the states have essentially been encouraged to adopt legislation that would implement the requirements of that convention. Again, even though everyone agrees that the convention is self-executing and would operate of its own force. There's many examples littered throughout this process where the states are encouraged to adopt legislation that would implement essentially treaty obligations the United States has either entered into or about to enter into. And the medium where I usually find this is in uniform laws. Uniform laws often have provisions that are put in by their drafters essentially with knowledge of and with the intention of implementing obligations that they know the United States is either thinking about or has entered into. One of my sort of examples that didn't quite get into the outline I gave here, the Wills Convention, the Washington Convention on Wills is like sort of my neat example where the United States signed, got advice and consent, but did not ratify the treaty. This is the really technical distinction between ratification and advice and consent, which I only learned about like years after law school. And so the president, I guess, has been holding this in his hand. He's got his advice and consent. He's not going to, because he's been waiting for, as Duncan and I think has pointed out, he's supposed to wait for the implementing legislation because they're not in compliance yet. But there's no, and they've been waiting for like 20 years and there's no prospect of any implementing legislation occurring. So what have the states done? They've just, the Uniform Probate Code has some provisions that implement essentially the wills, some provisions of this convention. States have adopted about half the states have adopted it. Therefore, it essentially works for half the states, doesn't work for the other half. Some states are essentially in compliance with this treaty. Some states are not. We may never get the federal legislation. I just don't know. All right. So let me sort of briefly get to, notice how this is a very brief paper but a very long talk, that why has this happened? Like, why is there this sort of, I mean, I think our discussion this morning has convinced me that, notwithstanding some quibbles on the edges, everyone agrees that there's a very broad federal power, either under Article 1, Section 8, or under the treaty clause, to really implement pretty much all of these obligations through federal law, through treaties or legislation. So why is this, at least I argue, in many ways left to the states? And it's not constitutionally mandated. I suggest it's just an example of how state control of certain areas of law, family law, right, commercial law, the types of law that we're talking private, what we commonly call private international law. It's just very sticky, right? The federal government just doesn't like to get involved. They don't like to sort of displace state law, and even if they know they have the power to do so. Maybe part of it is deference to local autonomy. Part of it's also deference to local expertise. A federalization of wills law is just it's a terrifying prospect for, federal legislators. Not terrifying in the sense that they just don't really know, they feel like they don't know what they're doing, they don't want to sort of screw everything up, and it just seems like classically something that's left to the states. And so I think what I'm sort of getting at, this model, I think, of this, it's this reluctance of the federal government, and there are some perhaps constitutional limitations, but they're not the main reason, I argue, why the feds have not federalized these areas. I suggest that at least there's some broader lessons we can draw from this story. Now, the continuing allocation of certain key private international law treaties to the states, I think, weakens the functional argument that I believe that both Professor Gulab and Professor Vasquez made, at least in passing a number of times this morning, which is, you just can't leave this to state implementation, right? It would just be, that would be inconsistent with the founders' design. It's exactly what the whole point of the Constitution's treaty regime is supposed to fix. And it would also be bad for a variety of other reasons. I'm suggesting that, and I've argued in other papers, and I argue again here, that maybe it is inconsistent with the founders' design. I'm not so sure about that. But it is, I think, actually the way that the system actually has evolved to work, at least in some areas, private international law being a great example, but perhaps in other areas. In other words, areas where the states really do essentially retain control over obligations and areas of regulation that would that could be the subject of international regulation, the states are essentially in the role of implementing these obligations on their own. And this is not something that's really terrifying even for foreigners, right? A different rule for will recognition might be effective in Missouri than in New York. So what, right? Some judgments, as I recently discovered, be adopted a child. Some adoptions some states recognize foreign adoptions, other states don't, right? Some states recognize certain foreign judgments, other states don't. It's not something that's actually very unusual. In fact, it's an enduring facet of the United States system of federalism. And this is already a reality. I've seen no strong evidence that the U.S. system cannot survive or even prosper under this kind of decentralized implementation model. And so other kinds of treaties, even perhaps, dare I say, human rights treaties, may benefit from the same model of implementation. Now, it's not to say that states must play the same role in the implementation of private international law or international treaty obligations as they do in the areas of private international law. And obviously, different considerations for models and implementation arise for different kinds of treaties. But at the very least, and I'll close with this, the story of states and private international law treaties that I've been trying to tell here offers a modest alternative to sweeping claims of the absolute necessity of foreign affairs nationalism and for all matters affecting foreign affairs. Even where federalization is possible, it's not always necessary or even desirable.
Well, thanks. Let me join again the chorus in thanking Peggy, the Missouri Law Review, and the organizers. So far, it's been a pretty fascinating morning. What I wanted to do, cognizant of the potential charge of knee-jerk nationalism from Julian, is that I wanted to talk about the appropriate legal framework under which the states of the United States go out and enter into agreements with foreign national governments and also foreign subnational governments under the so-called Compact Clause. Now, when I first broached this topic with someone who will remain anonymous, a senior international law colleague, I got what I'll call like the look. And maybe you've gotten the look in talking to friends about, kind of the glasses go down and get the sour face. And the ensuing discussion was I was informed that there was no there, and it wasn't worthy subject of discussion, of analysis, and I should be better off looking at things like dormant foreign affairs, international delegations, and the like. And as I looked into it, I found that with the notable exception of Ed Swain, it was not Peter Spiro. Peter's shaking his head, so I need to clarify.
We know he's not senior.
Right. But in any event, with the notable exception of Ed Swain, I found that most foreign relations scholarship largely ignores this foreign compact practice of the states. And I guess what I want to argue is that the time may have come to change that dynamic and to see if there's constitutional space for a distinct theory of foreign compacts. So I want to do that in kind of making 4 points. First, I want to give you a little more of an explanation of why I think the time has come to think about foreign compacts. Second, I want to talk about the current conventional wisdom which treats the compact clause as a single entity in which we equate the standards for interstate compacts to those for foreign compacts. Third, I want to challenge that conventional wisdom and kind of present what I think are the constitutional arguments that suggest maybe we should distinguish interstate and foreign compacts. And fourth, I want to try and sketch out some normative arguments for why I think that even if we can, as I say, unpack the compact clause, why we should do so. So first of all, why? Why should we care about state agreements with foreign powers? I can think of 3 quick reasons. First, as many of you know, we spent the better part of a decade engaged in a revisionist enterprise in foreign relations law. The new sovereigntists, to use the term Peter Spiro coined, have been kind of systematically working their way through the canons of foreign relations law and kind of revisiting them. And I'd argue that if we're going to revisit foreign relations law, we need to do so in its entirety. And so not just those provisions where it might be appropriate to scale back aggregations of federal power to the benefit of states' rights or states' autonomy, but also those provisions where actually existing state autonomy or states' rights might be scaled back in the face of federal interests. Second, I think even as the foreign relations law landscape isn't changing, it's important to recognize that there are also changes that have happened in the international landscape. At the time Holmes wrote Missouri, let alone at the time of the framing, I think you had this dominant view that treaties were the vehicle by which states did their agreements, and only states did treaties. I think clearly today, as important as treaties remain, that paradigm has changed in 2 key respects. First of all, treaties no longer represent the only vehicles by which agreements can be reached. We actually now have international law recognizing, if not governing, this notion of a whole separate sphere of normative political commitments, also known as non-legally binding agreements and the like, that is a vibrant practice in the international sphere. And second, it's no longer the case that states do treaties. They still do, but other actors do treaties now as well. Obviously, we all know the examples of aggregations of state power, international organizations, supranational organizations who do treaties. But with globalization's pressures on the unity of states, the possibility of sub-national treaty making has emerged as well. Now, why should that development affect the constitutional inquiry? I think, well, the reality is that at present, international law, what it says about sub-national treaty making is it can happen if the domestic sovereign authorizes it. So in other words, as a matter of international law, sub-national treaty making turns on questions of domestic law. So if we want to know whether U.S. states foreign activities or foreign agreements are legal under international law, we have to first turn to the domestic law question and ask as a constitutional matter, within what space can they do these agreements? Which brings me to my third and last reason for studying foreign compacts. And this is even just anecdotally, it appears U.S. states are doing a lot of agreeing with foreign governments. So a few quick examples. Last fall, 10 U.S. states joined with British Columbia, the European Commission, France, Germany, the Netherlands, Spain, the United Kingdom, and a bunch of other nations in a political declaration in which they agreed to form an international carbon action partnership, ICAP, that will promote mandatory cap and trade carbon markets, something, to kind of carry forward the Kyoto model for dealing with climate change issues. Another example, April 2006, Hawaii's governor entered into an agreement with China, the Chinese government, in which Hawaii agreed to exchange information and jointly promote tourism between the two sides. August 2004, North Carolina re-ups with Moldova in a memorandum, and I like this, which among other things contemplates joint military cooperation between the North Carolina National Guard and the Moldovan military. It's true. And because we're here, I can't resist pointing out that lest you think that this is on the periphery, here in the heartland, Missouri in 2001 concluded an MOU with Manitoba to mutually oppose interbasin water transfers, that is, from the Hudson River Bay Basin to from the Missouri River Basin to the Hudson Bay Basin, even in the face of a federal appropriation that contemplated such transfers. So I think clearly these developments taken together warrant our attention. Now, assuming we can agree it's a subject worthy of attention, the next question is, how have the U.S. states been making these agreements as a legal matter? I mean, after all, Article 1, Section 10 of the U.S. Constitution prohibits explicitly the U.S. states from entering into any, quote, treaty, alliance, or confederation. The same section contains the so-called Compact Clause, which prohibits states from entering into any agreement or compact with another state or with a foreign power absent congressional consent. But Congress didn't consent to any of these agreements I just listed. In fact, it appears that Congress had no role in their formation whatsoever. So you might think, well, these agreements are constitutionally problematic, if not prohibited. You'd be wrong. In fact, currently, neither the treaty prohibition nor the Compact Clause appear to have any real purchase in constraining what the states are actually out there doing, whether it's legal agreements or political agreements. Now, why is that? I think the answer lies in the fact that the other half of the Compact Clause, that is, the half that says states can't include agreements among themselves without congressional consent, has been read to the doctrines under that Interstate Compact Clause doctrine, have been read to cover foreign compacts as well. And when you look at that, for more than a century, dating back to 1893 in a Supreme Court case, Virginia v. Tennessee, we see the Supreme Court reading the prohibition on state compacts, interstate compacts, loosely. Basically saying, actually, any agreement or compact doesn't mean any agreement or compact. It means only those that would encroach on the just supremacy of the United States. More recently, the Court has actually said, and it turns out that some things that we might think of as agreements aren't actually agreements for purposes of the provision if they don't impose legal obligations on the parties, or they lack what the Court says are classic indicia of a compact, that is, some sort of joint organization with rule-making authority and restrictions on the ability of the states' parties to exit. And the dominant understanding today, as I suggested, is that those standards developed for interstate compacts translate seamlessly over to foreign compacts. That's the position of the Restatement on Foreign Relations, ditto, Luhenkin, numerous other scholars, and indeed it's the position of my former employer, the State Department Legal Advisor's Office. But actually, it turns out in asserting that analogy, or asserting that there is a single compact clause, the assumption that it translates seamlessly has gone largely unexamined and unchallenged. And I think if you actually look at it a bit closer, there are strong arguments for treating interstate and foreign compacts differently. Just like, for example, we treat interstate and foreign commerce differently under the Constitution, we could do the same with interstate and foreign compacts. What are the arguments? Well, I mean, we could start with the text, right? The text, as I said, no state shall, without the consent of Congress, enter into any agreement or compact with a foreign power. Of course, that hasn't stopped the Supreme Court in the interstate compacts from loosening up the ability of states to enter into agreements with each other. But I think there's a bit of a difference here. In the foreign compact context, you do have this prohibition on treaty making for the states. So you have this question of what is it the states are prohibited from doing absolutely, treaties, and what are they allowed to do with congressional consent, compacts. There's been a long-standing debate over how you make that distinction. There's a variety of theories. Some people want to go back to Vattel, the Swiss jurist, and say that his distinction between treaties and compacts informs the constitutional understanding. Ed Swain, as actually I think articulated a notion of a dormant treaty power, that we define prohibited treaties in terms of the power conferred on the federal government. Joseph Story said, let's use it as a political litmus test. The more political the agreement, it would be banned. Less political, it's okay. And Felix Frankfurter and James Landis, in a seminal article on interstate compacts, said it's a political question. It's not the court's job to draw the lines. It should be Congress's job to say what's prohibited and what they want to consent to. But what's interesting about that diversity of views is that all four, as different as they are, all share the assumption that the dichotomy is between what states are prohibited from doing absolutely and what they can do with the consent or participation of Congress. There's no third category there in which the states are allowed to do stuff unsupervised and unconsented to by Congress. And indeed, if you go back and look at the historical materials, I think this idea of not allowing foreign compacts without federal participation has historical support as well. Indeed, if you look at the two provisions, interstate and foreign compacts come from different places. Interstate compacts trace their origin to a colonial practice in which the states were basically looking to settle boundary disputes. They were looking to ways to kind of deal with boundary issues. And indeed, under the Articles of Confederation, it looks like they were able to do those agreements without any participation by Congress. Foreign compacts never had that permissive past. They are, on the contrary, the conditional prohibition, that is, you can't do it unless Congress says it's okay, seems to reflect concerns that foreign agreements, that is, when the states went out and negotiated with foreign governments, it could dissipate the U.S.'s bargaining power as a whole, and also threaten the unity of the United States in both its external and internal relations. And indeed, these concerns, in fact, appear to have motivated the one Supreme Court decision to opine on the issue. In Holmes v. Jennison, Chief Justice Taney read the requirement of congressional consent for a foreign compact quite broadly to cover, and I quote, every agreement, written or verbal, formal or informal, positive or implied by the mutual understandings of the parties. Now, I should be clear, I'm not actually citing Holmes to say that that's the doctrinal rule today, but rather for the proposition that it supports this notion that we can distinguish and come up with different standards for interstate and foreign compacts. And I also don't mean to rest my arguments solely on text and history and doctrine, as strong as those arguments can be. I think we actually can find functional differences between what the goal of having congressional involvement in interstate compacts versus that for foreign compacts. For starters, I'm not sure I buy this idea in the interstate context that it's all about protecting federal supremacy. Because if it was about protecting federal supremacy, you could do that just as well, if not better, by having congressional consent for all interstate compacts. In fact, what I think is really going on, the function that's being served in the interstate context, is we're preserving state autonomy, right? We're preserving a zone of activity where the states can cooperate and coordinate and be innovative and do all these things free from federal interference. It's kind of that dual categorical model of federalism where there's a zone for the states and a zone for the federal government, and we draw a line between the two. But if that's the case for interstate, I'm not sure that it translates to foreign compacts where you've got a very different set of issues. And indeed, foreign compacts, I think, are designed to function in ways that we want to avoid certain risks. First of all, the idea is that foreign compacts might interfere with the federal foreign affairs activity. Obviously, this would invoke ideas of one voice, right, that a foreign compact might confuse foreign governments as to what the federal position is, or it might undermine that federal position. But it's not just that. I mean, the other thing that they do is their agreements, right, and their performance, it can be triggered, and the United States may be held accountable for what the state agreement is, whether it's legal or political, and the whole of the United States may be on the hook for what the states are doing. And indeed, the fact of the states going out and negotiating, for example, with subnational foreign governments, may put the United States on the hook by mere virtue of the fact that our states are negotiating with subnational actors. Canada kind of repeatedly complains to the United States that our states are out there negotiating with its provinces who don't have any such capacity to do treaties, as it were. I think equally important, though, is there's a separate risk here, which is the notion that in foreign compacts, we're trying to protect the internal functioning of the United States from subversive or dangerous external influences. The idea that foreign governments might seek out U.S. states to kind of get agents within the U.S. democratic process that will do their bidding or be sympathetic to their views, rather than going through their own diplomatic methods vis-a-vis the federal government. Now, I guess perhaps my most controversial suggestion is that these functions also would support including political commitments alongside legal agreements within a foreign compact clause. Clearly, that's not contemplated by the framers. Indeed, I don't think this category of political commitments really existed at the time of the framing. But I'd argue once we think functionally that political commitments raise the same sort of risks that legal agreements would in terms of requiring federal attention. They can be really significant. The Atlantic Charter, the Shanghai Communique, not treaties, political commitments. They can involve large organizations. The Organization of Security and Cooperation in Europe, thousands of employees, not based on a treaty, but based on a political commitment. So I think we have to think long and hard before we want to say that states can use its political excuse as a get-out-of-jail-free card when they're out there negotiating agreements with states, because indeed it does seem that what they try and do is do these elaborate agreements and then say, oh, but it's political, as if that somehow immunizes them from federal supervision. And finally, in terms of my arguments for separate foreign compact clause, I'd make a couple structural points. One is, I'm not sure that federal supremacy is what we should be talking about when we talk about compacts. The compact clauses, both interstate and foreign, have different origins. They are the last vestiges of Madison's negative, right? This idea that rather than a system of federal supremacy, we'd have a system where the state's actions require congressional approval before they can have legal effect. And so I'm not really sure why we want to translate a very different structural orientation of federal supremacy onto clauses that are based on a fundamentally different structure. But even for me, the real structural problem goes between the separation of powers issues. Because in effect what's happened is the federal courts, by coming in the interstate context and divvying out and saying some compacts or agreements don't need to go to Congress, they've grabbed power from Congress. Because if you look at the text, the default position is Congress has all the power to make the decisions what's okay, what's not okay. And the courts have effectively taken some of that power, a large portion of that power, away from Congress. And indeed, in some ways you could say it's the court's compact clause now, because what happens is states go to the courts and say, will you approve this for us? Will you certify that this is something that we didn't need to go to Congress for because it lacks classic indicia, or it's not legally binding, or it doesn't encroach on federal supremacy? And indeed, it turns out that nobody has submitted a foreign compact to the Congress in 35 years, right? That just states don't go and take these agreements to Congress anymore. And so I think whatever the merits might be for this judicial power grab in the interstate context, I don't see it translating well into the foreign context, where the political branches do have a clearly assigned foreign affairs function that warrants attention, and that can be interfered with by having the courts carve out lines that may not be the same lines that the political branches would draw. So I think taken together, I want to make the argument that this notion that interstate and foreign compacts should be treated the same rests on somewhat shaky foundations, or at least requires some examination. I'm running low on time, so let me just finish with my fourth point, which is that assuming we could unpack the compact clause, I recognize we still have a normative inquiry. Should we do so? Does it, just because we can doesn't mean we should. And in saying that, I don't want to minimize the fact that there would be costs in having a separate foreign compact clause when you look at the status quo, right? Some of the agreements states might be doing now might be disapproved. Some might be conditioned by Congress. There might be a chilling effect on what the states are doing by virtue of the fact of having to go to the federal government. There's transaction costs in terms of having to bring the feds into the picture. But I don't want to, and I also don't want to minimize the cost of what those agreements do, right? They often address collective action or coordination problems that might not get addressed in the absence of the interstate compact. But at the same time, I don't think we should overestimate those costs, because it's not saying, to say there's a foreign compact clause, that we're going to have federal preemption, right? It's not federal preemption. It's simply involving the federal government to participate in the decisions about what sort of compacts we want. And it's perfectly reasonable to suspect that in many instances, the federal government might tell the states, yes, go ahead. We recognize this is something valuable. We want you to go out and do this. And at the same time, I think having federal participation brings with it its own benefits. Not just those functional benefits that I've already discussed, but some internal and external benefits as well. One, I think it provides some information, right? Right now, we don't know what the states are doing. It's anecdotal at best. It's what the states want to tell us. In the Q&A, if anybody wants to know, I'll tell a story about the California-UK climate change agreement that California seems not to be as enthusiastic about letting us know about these days as it was when it announced it. And so what a federal role would do is correct that information deficit so that other states and the federal government can know what states are doing out there when they negotiate with foreign powers. And externally, a foreign compact clause would provide a signaling effect, both to foreign governments, right? It would show to foreign governments, yes, you can negotiate with our subnational actors, go ahead and do this. At the same time as it might caution federal governments who've seen these compacts as an avenue to do end runs around federal policy and positions, that they might have a chilling effect, and we might not have those sorts of agreements that would risk subversive or dangerous interference. Now, let me close with saying Earl Fry, who's kind of a fan of municipal diplomacy, says what I propose is impossible, right? That there's no way the federal government can control, supervise, or even monitor all these activities. I'm not so sure. I think certainly under the orthodox position that's true, but Congress is pretty inventive. I mean, it's perfectly plausible to think that Congress could pre-authorize whole swaths of state foreign compacts. It's also possible that Congress could adopt a case sublocki act sort of approach, where the states have to notify Congress of what compacts they've entered into, and then, you know, if Congress feels that it warrants attention, then they have the notice in which they could then react. But you would, in some sense, want to have some federal role. And finally, I'd add, it's not entirely clear to me that it has to be Congress. You know, the executive has this treaty power that could play into this, and indeed, the North Carolina-Moldova MOU I mentioned at the beginning, I should say, although Congress had no role in it, it was authorized by the Defense Department, who kind of participated in the formation and implementation of that agreement, lest you worry that North Carolina is going to secede again or something. In the end, I think I see foreign compacts not as this kind of dualist, what's federal power, what's state power, but an area actually, building on Judith Resnick's idea, for multifaceted federalism. An area where the federal government and the states have to cooperate to get these compacts to occur. So rather than kind of thinking about it in terms of the states saying, you can't touch us, federal government, and the federal government saying, I'm going to preempt you through some dormant foreign affairs power, we have in the Foreign Compact Clause an opportunity to see how the federal government and the states can work together jointly in this much more globalized and complex world. Of course, to do that, the first thing we've got to do is unpack the Compact Clause.
Okay, I think we decided that I'm going to go first. Penny, thank you very much for not only including me, but for prodding me at various occasions that I try to get out of this commitment to stay in. I can't tell you what a treat it is to be here. Some of us talk about either being left-brained or right-brained. Right now, I sort of think about being dean-brained and non-dean-brained, and I have not had a lot of opportunity to turn on my non-dean brain, and it felt really fantastic in the past 24 hours to do that. So thank you, and thank you to the law review students also. I feel somewhat like an interloper in this group. I'm not a foreign affairs specialist. I'm not a constitutionalist. In fact, many of the people in this room, I rely on your seminal articles as my cliff notes when I quickly go through these sections in my international law class, go as fast as I can over some of these different constitutional issues so I can get to some of the commercial work that I feel more comfortable with. So I want to preface this by saying I admire so much of the work of those who are on this panel and the papers that were produced, and I hope that someday I have the chance to do the constitutional historical analysis that so many people in this room have done. But I'm going to root my remarks in my scholarship, which takes a more, I would say, socio-legal bent that looks at how international law is made and enforced on the ground, or at the touch points. Sometimes in my work I call it in the heartland. And I have looked at this question in a variety of contexts. Some of my longer papers have looked at various aspects of commercial law and trade finance law, and then I sort of have forayed into consular notification, and also most recently into some climate change regulation. So with that preface, I'm going to say that while I realize that this is a conference on Missouri versus Holland and on federalism issues, I sort of find this federalism discussion and debate overly simplistic and relying on a lot of binary choices, a lot of blacks and whites, either-ors, zero-sum choices that don't really resonate all that strongly with the way I see how it's played out in some of my studies that I would call more socio-legal. So I'm just gonna focus on three of these. The first is the notion, Paul Stephan's notion of opportunism, what that means versus localism. The second is sort of a view of what I think is somewhat of a simplified view of who makes and implements international law. And the third, I think, is a presumption that many of us have in this room, that if we can just identify who could be in control, then that's the tough issue, or who should be in control. But I think I want to raise the question of whether it's even possible to control or have a deliberate course of international law, or whether international law actually just happens in a more of a spontaneous way. So I'll start with opportunism. I've been tracking, it's really an honor to be on the panel with Paul Stephan, because I've been tracking his work for a long time when we write in some of the same commercial areas. And his argument that the federal government, essentially, the way I take his argument is the federal government need not supervise state courts or state lawmakers because states do not always engage in local opportunism, and opportunism is defined as sort of being unable to internalize the perspectives of the outsider. So there's a dichotomy between insider and outsider that comes out in the paper. And I have to say that a lot in the paper really resonated with me, and a lot of your comments about bankers and the role of bankers and the bankers' lobby. But I think that the definition of opportunism, maybe we've seen it played out in other contexts of, maybe opportunism is just another way to say interest, local interest. That sort of presupposes that we're able to identify what opportunism is, what those interests are, and also that those interests will seem to be in opposition to an outsider. And so I want to look at two examples from my work, one in where the states did not, at least on the surface, did not act as an opportunist, or the state court did not act as an opportunist, and the second is where a state did, using your definition, and just to show, not that it's wrong, but it's more complex, more multifaceted. So let's take the Oklahoma Court of Criminal Appeals. I know that Paul Berman is going to be talking about that later, but we all know that that the Oklahoma Court of Criminal Appeals responded to the Avena case by essentially following the international court. From our perspective sitting in this room, maybe we'd say that the court decided to not act in an opportunist way. We know that Oklahoma is an incredibly red state. We know the death penalty polls extremely well in Oklahoma. We know the governor who actually pardoned in that case, and the Court of Criminal Appeals, who are elected, is responsive to, it has to answer to those polls. However, the court and the governor decided to follow sort of the ICJ in that case. So why did it do this? Well, I'd say because it was responding to a multiplicity of local interests, not just sort of the conservative anti-death penalty, but also what was a growing sense that there would be economic retaliation to the state, primarily from Mexico, if the decision came out otherwise, and also actually a sense, I'd say maybe, believe it or not, a cosmopolitan sense among some of the decision makers that they wanted to make a decision that seemed more global. So while that decision may look like it was not an opportunist decision, it may actually have been an opportunist decision, but opportunism just is more complex than it might appear on the surface. The reverse, I have a piece coming out on letters of credit in a couple months, and the state of New York actually opted out for a long time of the UCC, Article 5 of the UCC, which is the standard article which essentially governs letter of credit, which all other states have opted into. That might be seen as an opportunist decision, right? New York was trying to capture rents. However, in opting out of the UCC, they opted into something called the UCP, which is essentially an international code, which we'll talk a bit about in a moment, that bankers made that governs all aspects of letters of credit. So again, it's not so easy to identify what opportunism means in these cases as opposed to localism or nationalism. And so I would just beg a bit more nuance there. The second overly simplistic assumption is really in the panelists asking the questions of who are the legitimate actors in international law? Are they the federal government or the state government? That's an important question, and a question that is driven clearly by a doctrine, a world of doctrine that I don't engage in directly. But I just want to note here that this really misses a host of actors which are extremely important. I think all of the papers recognize this, but don't really contend with it in a robust way. Recently, I've started to look at the role of municipalities, actually influenced greatly by Judith Resnick's work, and I did a little empirical study about Tulsa becoming a green city, and it was prompted by the mayor's decision to the 500th signature on the Compact of Mayors. And what this study showed, and it was a study done with Hari Ostofsky, where we compared Portland and Tulsa, so a heartland city and a coastal city. What this showed is that a municipality, even in making micro decisions, for example, in telling police officers that they can no longer drive their cars if they're off duty, or in sort of punishing or garnering in wages for certain decisions that might have environmental impact, that the conglomeration of these micro decisions can have not only climate change conscious changing effect, but also a regulatory effect that is very important. And of course, private actors are a group that Paul alludes to in the bankers, but I think that is largely missed in this discussion. I think it's extremely important. Let's just take a couple examples. If we take some of Julian's outline, which I must admit to have looked at only about 5 minutes before this talk, but Julian's outline, what we see is state law in maybe some of the realms of private law. Let's just take my letters of credit example, but you can also take one of the examples that Julian lists, standby letters of credit. We might say that looks like state law. It might be embedded in a uniform code, but that code actually embodies and borrows completely from private law, the law of these private, I call them sort of private micro communities. Others have called them something else. So while letters of credit are governed by the uniform customs and practices, and essentially the uniform laws adopt that in whole, standbys are also essentially governed by the ISP 98, which is the same type of deal. And not only are these rules that state judges may or may not use to come to decisions, federal judges may or may not use to come to decisions, but they're rules that actually are being adjudicated and enforced independent of any court, independent of any country. They're being enforced in highly specialized arbitral tribunals, which is something that's just missed. I see my time is out. So let me just allude to my last, what I would call oversimplicity, and that is the sense that the search for who should control or who should have autonomy over international lawmaking seems to me to be overly idealistic and not really grounded in reality, because I really do believe, and I presented a paper once with this title, and I really do believe that international law has a momentum of its own. International law happens whether the federal government wants it or not in many instances. I think we could talk about sort of climate change coalitions to show that. I think international law, I've talked about it in the trade area, while the federal government, we may have decided that the federal government should have control over treaty making in the area of government subsidies or export subsidies. The reality is a whole group of private actors came together and really decided in a couple of particular instances, and export credit guarantees and export credit insurance, what those subsidies should look like. And the treaties either just borrow that decision making or are constrained by it. And so I guess I leave you with just my thought that international law really happens, and it happens whether we decide the federal government should control it or whether the state government should control it. That it often has a momentum and force of its own, and that when you look at how this is all playing out on the ground as opposed to what the doctrine says it should be, I think the picture is quite different.
I guess I bring to the symposium more of the practical orientation of someone who by profession negotiates international treaties and then tries to get them accepted, ratified, and implemented. So my perspective will be perhaps less theoretical, less academic, and more towards the practical. Just as a point of departure, I found Dean Levin's comments very, very interesting, but my reaction is international law happens, but part of what we do for a living is trying to make it happen in the right way, that is, the way that's beneficial for the United States, for our national interests, for our commercial interests, and so on. The idea that it happens without us usually gives some cause for worry and concern, because often it comes out the wrong way if we're not there at the table. I should say at the beginning, too, I'm speaking personally, obviously from personal experience in the government, but what I say is not necessarily what the boss would say if he heard it. But I want to bring the perspective of someone who focuses currently on private international law. That's a subject that the panelists have talked about, and it frames the issue of Missouri v. Holland, of these federal state issues, in a very, very clear way. Much of what we do in our office, we're a small office, is negotiate treaties dealing with issues of private international law in a variety of international bodies, particularly the Hague Conference on Private International Law. In the UN, it's the UN Commission on International Trade Law, UNCITRAL. Also in an outfit in Rome known as UNIDROIT, the Institute for the Unification of Private Law, within the OAS, and a variety of other areas. Now, typically these subjects involve topics on which the federal government, certainly the legal advisor's office in the State Department, are not experts. Take family law, for example, child support issues, or securitization, or electronic commerce, or enforcement of judgments, or insolvency. These are things that are dealt with, if at all, in the federal government and other agencies, but often primarily by practitioners and by legislatures at the state level, so that much of what we do is actually in conjunction with other departments of the government, but increasingly in coordination with representatives of the states, and we have a very close and growing relationship with the Uniform Law Commissioners, for example. Very, very close relationships with a variety of bar associations and professional interests, so that we can inform ourselves about the status of U.S. law, about what are our interests, what are the interests of U.S. As a whole, either in terms of individuals or states, and how do we want the law as it develops to be formulated. Very frequently we find that the views that, let's say, the French have, or the Moldovans have, or the Chinese have, are not consistent with the way we think the law should develop. And so often we are in the position of trying to advocate that the international rules should be the ones that, particularly in the commercial area, that we have found over time to be the best market-based, influenced, and so on. That's not always the case, and we're always in the business of compromising. Of course, you can never get what you want, particularly in the UN. If you can get something sensible, you're doing very well within the UN in particular. So there's a dynamic process. But the point that I want to emphasize as a result of this conference, I have to say this issue, Peggy, is at the center of what we do. Missouri v. Holland is always on our minds. The idea that we go negotiate treaties and aren't thinking about how the U.S. government would implement the treaty, or how the Senate might react, is really quite amazing. It's foremost. We sit at the table, and you've got two processes going on. One is, what's the substance? What are we trying to accomplish? And the second is, can I take this home and get the president to sign it and the Senate to ratify it? Would the states, would Inkusel endorse it? Would the folks in Missouri say this is a good thing? Because otherwise we're not doing our job correctly. With regard to the three presenters, I am in the happy position of saying I agree with most of what they've said, and I think it's a terrific set of presentations. All of them invite us to revisit the allocation of authority and involvement in the area of particularly private international law, but in foreign affairs law. And I think that's in light of recent developments, and I think that's a very encouraging thing. Having spent a career working for the State Department and the federal government, I've come to think that Federalizing everything and having the federal government do it all is not necessarily a healthy thing. All provide credible arguments against the dormant preemption idea, and I think that's also a very healthy thing. It encourages us to think about a broader role for the states and localities. Stephan encourages us to think about states as implementers rather than lawmakers. I think you're quite right on that, Paul, and Julian and Duncan encourage us to think about states as participants. Where they differ, and the one point that I would like to emphasize is on the control function of the federal government. And Paul, I think my one comment about your paper would be that it really is important, particularly where these issues are being dealt with by treaty, to retain in the federal government some measure of control. And that's why I think, Duncan, I think you're quite right in your proposal. Not because the federal government knows better, but because the federal government has the responsibility for ensuring that we carry out our treaty obligations. The argument might be different if we're talking about customary international law, but always when we're doing agreements through the treaty power, the federal government has the responsibility to ensure that we will be able to carry out our international obligations. Other states require that. It's not just an aggrandizement of power or a notion of self-interest. It is that other states, other countries in the world want the federal government to say, well, can you deliver, or is Missouri going to opt out? We have, and this isn't an issue that's unique to private international law. It comes up in the human rights area and others. When I was doing human rights treaties, we always had in our mind what I called the recalcitrant state. I usually pick on Utah, but it could be some others. In whatever situation, there's often a state which says, we don't care what you folks in Washington are doing or what all the 49 other states do. We're going to do it our way here. And I think you've mentioned one. You can probably all imagine others. When you're dealing with a treaty issue, that's a very problematic situation, because unlike Canada and some other nations, we don't have a structure that says we'll implement the treaty only in those component constituent units that accept it and otherwise not. We can't exempt Saskatchewan, for example, Saskatchewan. It's all or nothing for us. Either we do it or we don't. So that control function remains important, and that's always in our mind, and that's one reason why Missouri v. Holland is so important. The other thing I'd mention is that I find so encouraging is the notion that it's not an all or nothing. It's neither, if we're doing something by a treaty, it's not necessarily self-executing or non-self-executing plus federal legislation. The point has been made over and over that federalizing issues necessarily isn't the best option. In the private international law area, for example, we're looking at a variety of options. One is to have a structure in which the states actually implement the obligations of the treaty with some measure of control by the federal government to ensure that we can comply with our treaty obligations. Paul describes the Child Support Convention, which we have recently signed on the basis that the federal spending power in the area of child support is so forceful that it has never happened, and it's not necessarily linked just to the treaty, it has to do with other things. No state has opted out of this system. And so on that basis, we think that it's highly unlikely a state would not comply with the provisions of the treaty. Still, we're seeking some measure of congressional endorsement through legislation that says implementation of the treaty is the policy of the government, and the mechanism that now exists will be administered in such a way as to encourage that. That leaves to the states, in that case, it leaves an existing mechanism for implementation in place and, in effect, grasps onto it the treaty obligations. Paul also mentioned the e-commerce convention. There you have an existing sharing of authority by the federal and state governments. You have a federal statute which allows the states to, in effect, opt out through the adoption of a uniform law. This has some real attractions, of course, because it allows states to, within some range, some flexible range given by the treaty, to implement the provisions of the treaty subject to some measure of control. The obvious problem there is, how do you prevent the 49th state from saying we're not going to do it? Relatively few of the uniform laws are actually adopted by all jurisdictions. Uniform Commercial Code would be one, but even there are variations. So that can be a limited factor. We're looking at the same thing, same approach in the case of the choice of court convention, which is a sort of a mini enforcement of judgments convention, to see if we can construct a way of what I try to call, I haven't got the right name, sort of cooperative federalism, creative federalism. It needs a slogan that will attract the necessary support in the Senate, but which would, in effect, allow the states to manage these issues in which they are already the primary actor under the aegis of a treaty. There could be other solutions here, but all of these depend on a kind of a very cooperative and energetic relationship between the federal government, the treaty makers, and the state lawmakers and the practitioners. So this actually is a dimension that's relatively recent in development. We spend a lot of our time, as I say, working with NCUSL and working with other private sector folks in order to generate the necessary understanding and the cooperative. There are those who feel very strongly that when it comes to treaties, self-execution is the way to go. The Convention on International Sale of Goods, I'm not sure it would go through the Senate on the same basis today, Julian. Is it a problem, though? Here's a question for you. The Convention on the International Sale of Goods, which regulates things that otherwise would not be regulated for the most part, by the federal government, was adopted, was implemented, is being applied by the courts. You see very little controversy about it. It's rather amazing. For those people who adhere to the self-execution notion, and that from the federal perspective is very easy. It's nifty, it's over and it's done and terrific and we can move on. None of this messy cooperation stuff. Is an argument in favor of self-execution. My own inclination is that's not probably the way to go, particularly as law develops, and you're quite right, law continues to develop. I want to make one final point coming back to Carlos's discussion and Nick's about what's vague and what's anticipatory and so on. In the private international law area, most of what we do is very concrete. This is the rule that will apply in this situation. It kind of mimics, let's say, things that are done in the Uniform Code. So you don't have a lot of ambiguity. If you look at the same issue in the area of human rights, has been pointed out, you get a mixture of things that are vague or anticipatory or developmental, and it becomes much less clear exactly how that goes. Carlos, I guess there you are. You had mentioned the charter provision on promoting human rights. That's a rather vague thing. But take a look at, let's say, the Rights of the Child Convention, which the United States is, with the exception of one other country, Somalia, which really doesn't exist for these purposes, the only state that hasn't ratified it. And the reason we haven't ratified it, in my view, is precisely federalism. It's exactly what we're talking about. There are provisions, for example, one that comes to mind, providing, it says, every child shall have the right to rest and leisure and age-appropriate recreation. Now, I would think that's probably pretty specific. It's not anticipatory or developmental or prescriptive. It says you have that right. I have no idea exactly what it means or how the United States would implement it, by self-execution or through federal legislation or through some cooperative endeavor. That one just sticks out there as some treaties are going to be very difficult no matter what structure you adopt. In the CEDAW area, you have progressive implementation. That's a different animal. We don't face that in the area of private international law, which is one reason why I think these cooperative ventures have a much more promise. And so I'll stop there. Thanks.
And if we have time, obviously, to talk about lots of questions and comments and running out of time. Let's take 5 minutes. I'm going to comment that and have 5 minutes to respond, and then Q&A will have to be exhausted at the afternoon session.
I'll try and keep it to 2 minutes because I'm hungry. On Dean Levit's point about complexity, I agree. It actually brings, I think, a much bigger methodological point, maybe one we'll discuss more this afternoon. But, for those of us who want to be good technical lawyers but don't want to be bullied by historians, which is me, I think that you either end up being economically minded or you end up being sociologically minded. And I think both are legitimate ways of going about the business. Those of us who like the economic framework say, okay, by modeling, we are obviously engaging in superficial simplification of problems, but if we're lucky, if we're good, we get some predictive capacity and therefore the possibility of falsification, which I think is harder in other social science methodologies. And on David's point about ultimate federal control, of course that's right. Part of my project, which is, often crops up as a project in a lot of contexts, is to fight the conflation of federal control with federal judicial control. And one of the things I'm trying to do here is illustrate how we can bypass the federal courts entirely and yet get, a good enough for government work result.
I'd make one quick point, and it kind of responds to Janet's point. I take the complexity point. I think it's well made. I guess for me, the challenge though to this idea that we shouldn't be searching for authority, I guess I'd resist that a bit in the sense, because my own sense is there's always authority somewhere. It may be diffuse, it may be centralized, it may be one place or the other. And so I think a lot of the project is to ask, where is the authority, and is that the optimal or best place for it, or are there other arrangements of authority that might lead to better results? It's obviously both a descriptive and a normative inquiry. So I guess to the question, if you're suggesting that we shouldn't be spending time searching for authority, I'm not so sure, notwithstanding the fact that I think it's often a complex question, and that when we say international law happens, yeah, it happens, it just means that authority is now diffused through multiple actors, and that we probably shouldn't think about it simply in terms of, one actor or two actors or three actors, but that it's taking place at multiple levels in multiple contexts.
But even if you decide where you think it optimally should be, it doesn't mean you can actually get it there.
Right.
So I guess that was the point.
Yeah, I just wanted to just touch on one, emphasize one point I made, which I think may have gotten a little bit lost, and then actually ask David a question, or more broadly a question for the folks at the conference. First, I just wanted sort of to reiterate that I think that David's remarks I take to be recognizing that the people actually know what's going on, like him, who are doing this, that there is this sort of, there's complexity to the relationship between the federal treaty makers and the state governments that is sometimes lost in a lot of the literature, right? The literature is like, federal government, foreign affairs, it's the knee-jerk, right? Well, actually, this panel, right? It's states bad, right? Founders hated states. Foreign affairs, get them out, right? And that's obviously not true either on the ground, and I argue it's never really been true. And I think that some of the literature, although it doesn't say it that way, is informed by this sort of sensibility. And I think that's we need a corrective against that. And that leads into the broader point that we do have effectively states participating actively in this area as, if not primary, at least sort of secondary implementers of international law treaty obligations, which is a remarkable thing, something which seems kind of odd if you think about it in the sort of the very strict nationalist way that I've been trying to critique. On the other hand, I think David raised a nice point, which is that, federal government must maintain control. No matter how cooperative we get, we need to make sure that, at least the way he puts it, as I understand it, we need to make sure that we have an obligation to make sure it's implemented. And so if we completely abdicate and let the states sort of kind of implement it on their own, then that's really maybe what the problem is. And then we need some sort of hammer at the end to make sure everyone gets on board. Otherwise, you have this disuniformity. And I want to resist that a little. I understand that there might be this international law obligation to do that. But I think that, I wonder how strictly that obligation needs to be interpreted, in the sense that if you make a good faith effort to have your state governments participate in the implementation of an international treaty obligation that you've undertaken, and that it's a slow process by which the states will slowly adopt it, it doesn't strike me that violates that obligation under international law, that if you are saying, just as other countries do, will allow their states to perhaps slowly implement it. I don't know enough about this area of law to say whether that's true, but my suggestion is that the larger point is, why can't we live with disuniformity? Right? Why can't we live with some states adopting certain rules and certain sort of essentially conforming to certain international regimes and other states not? What is sort of wrong with that sort of as a practical matter? I understand there might be some legal obligations, and I argue that's effectively what we have, especially if we do rely on the uniform law system as an important way to implement some of these obligations.
Well, I sorry to cut you off here.
That's
but
all right.
we do have to suggest where you're going to assemble when we get across the quad, and that means that it's still supposed to